All right. Hello, everyone. Welcome back to another episode of Gotham Writers Inside Writing. This show is presented by Gotham Writers, offering writing classes of all types and sizes. You can visit us online at gothamwriters.com. Before we get started, a couple of announcements. First, the Gotham Writers Conference is open for registration and filling up fast. So if you have projects you want to get in front of agents, I would advise checking that out on the Gotham website. Again, that's gothamwriters.com. Secondly, if this is your first time joining us for Inside Writing, welcome. If you want to get caught up on all of our previous seasons and episodes, you can visit us you can visit the Gotham Writers YouTube channel or any major podcasting platform. And while you're there, like us, subscribe, leave a review. It helps to spread the word. Okay, regarding today, a reminder that at any point in this show, you can use the Q&A function to ask questions of our panelists. So for those of you who have done Zoom before, you're probably familiar with how Zoom works, but on the dashboard there at the bottom, you'll see a Q&A button. For questions that you want to pose to the panelists, go ahead and put your question in there. The sooner, the better. And then there's also a chat option down there. That's just for, general chat with all of the attendees out there. So again, Q&A in the Q&A and general chat with all the attendees in the chat. Now then, on to the conversation for today. So today we're dipping back into the old form of Inside Writing with two guests. They're both here to talk about the law side of publishing. So our first guest, Joseph Perry, is an attorney who counsels clients in the publishing and music industries and the founder of the literary agency Perry Literary Incorporated. As an agent, he represents best-selling cookbook authors, athletes, musicians, journalists, influencers, academics, and more. Hello, Joe.
Hi, Josh. Thanks so much for having me. I really appreciate it.
Absolutely. And our second guest, Jennifer Chen Tran, is a literary agent at Bradford Literary Agency and a publishing attorney. As an attorney, she has represented visual artists, entrepreneurs, writers, and other individuals in the creative space. As an agent, she represents graphic novels in middle grade and young adult, as well as adult fiction and nonfiction, including cooking, lifestyle, health, parenting, and business. Hello, Jen.
Hi, thanks for having us.
Absolutely. Yeah, thank you both for being here. So I want to start with the bare bones of what publishing law looks like. So let's start, Jen, we'll start with you. In a sentence or two, can you tell me what you do on the legal side of publishing?
Absolutely. So, I've been in the publishing world for a while now, over a decade, and I basically work with authors and other creative types to protect their rights under copyright law. So that can take many forms. That might be involving publication review in terms of the publishing contract, negotiating the terms of the publishing contract, especially for writers or individuals that don't have representation. I've also gotten rights reversions for authors before where they want their rights reverted from a previously published book. And we've done libel and defamation review as well. So there's a lot of different areas that a publishing attorney can work on. But the big picture is we're here to protect the author's rights.
Mm-hmm. Joe, do you have anything to add to that as far as what you do?
So I do a lot of similar things. So I review, draft, negotiate all types of publishing agreements, from agent agreements, editorial services agreements, to your traditional publishing agreement, option agreements, attachment agreements. I'm trying to think. Let's ghostwriting, collaboration, what you name it, I've done it. Rights reversions, I've helped register copyrights. And Jen and I, we actually just started helping authors start their own publishing companies. So that's something new that we've done.
Awesome. Yeah, and you both brought up some good points there that I want to get back to, but I want to get into sort of, Joe, I start with you on this. When should a writer first start thinking about protecting their work? Like at what point in the creative stages?
So technically, as soon as you save your work to Microsoft Word, it already is protected. So that's under copyright law. So I get this question all the time. So the next step would be to register your work. And it all depends on what you want to do for that. If you're traditionally published, a lot of times the publisher will register the copyright for you. You would want to make sure you ask to have that registered in your name. But if you're self-publishing it, that's a different story. Then likely the onus would be on you to register it. But technically speaking, it's already protected. The reason why you want to register is that you can't file a lawsuit in federal court for copyright infringement, and you can't get statutory damages. So that's why they say register early, so you don't fall into that trap where the infringement happens and then you're not eligible for the statutory damage, because they're a lot. They're like tens of thousands of dollars to hundreds of thousands of dollars, depending on what it is.
Jen, do you have anything to add to that as far as when writers should start thinking about protection?
Yeah, it's a really great question. And I think, unfortunately, a lot of writers are under the illusion that they need to have like the copyright symbol on their manuscript in order for it to be protected. And that's not true. As Joe said, as soon as it's in a fixed, tangible form, it's technically protected under copyright law, and you don't need that little symbol. I mean, you can always put it there. There's no harm in doing that. That puts people on notice, but technically it's already protected under copyright law.
So this is a question that we get at Gotham quite often as well, which is when I go into a workshop and I'm workshopping my work, is my stuff protected? Like what's protecting me from other people stealing what I've written? So Jen, what I'm gathering is it already is, right?
It is already protected. Where it gets a little tricky is that copyright law does not protect ideas, just the expression of ideas. So, a lot of times when you're workshopping, people might be like, oh, that was my idea, but, that's not actionable under copyright law. It's the expression of those ideas. So, I think a lot of people do want to hold their manuscripts close to their chest because they're paranoid that other people might steal their ideas, but ideas are not copyrightable.
Mm-hmm. And Joe, is that a situation you deal with often with like plagiarism or people's work being stolen, that kind of stuff?
Yeah, I mean, it's happened from time to time where people think that, let me take a step back. Some people will claim that, plagiarism and copyright are two different things. So for plagiarism, not so much these days. Sometimes that happens, but it's mainly copyright infringement, or it's mainly basically along the same lines of what Jen had said. Someone stole my idea. And that's really 9 times out of 10, that's what it really comes down to. Because in that situation, if you're in a workshop, how it would work is you would have to prove copyright infringement, you would have to prove access. So that person would have to have a copy of your work. And then you would have to prove substantial similarity, that that person's work basically copied from you, which on paper may seem easy enough because it's you're in a workshop, but there's a lot of time and effort that goes into just filing a copyright infringement lawsuit anyway. So it's like you need a $75,000 threshold to get into federal court anyway. So I'm just saying that, just thinking down the line in case this is happening to any of your authors. It's expensive, takes a ton of time. So there are some other things that you might want to think about in terms of mitigating that. I mean, the other question, I guess the follow-up question I get to that is, well, can I draft an NDA? Well, sure you can, but try to read the room a little bit. What's the the type of group that you're in a sense, are they going to really want you in there if you're going to sign an NDA? And I get the same question from being an agent. Do I need to sign an NDA to give to editors? And that's just not how everything goes. I think there's just an implicit trust with editors. I know that's a totally different realm, but these things are all interrelated. And I get that particular question a lot on the agency side.
Jen, do you have anything to add to that?
No, I think Joe pretty much covered it, but basically, there are non-disclosure agreements. Are they common in publishing? Not always. I did have a situation on the literary agenting side where my client is working with Disney, and that's all I can say about it because I had to sign a non-disclosure agreement for that. So there are certain projects, especially along the lines of work for hire, that might require a non-disclosure, but for the most part, we don't use them that often.
Mm-hmm. So, like, for instance, I did not. Sorry to jump in, but it just reminded me. I have a project that's potentially getting optioned as well, and I made the production company sign an NDA to just read the proposal, just because I've just heard some crazy stories in the film industry. So just to protect her. So that was a situation where I insisted that an NDA would be signed, and that's also particularly to protect the work because the work hasn't been published yet. And part of the chapters, even though they'll be edited, the content is there, and I don't want it to get out, anything to get leaked, et cetera, et cetera.
Mm-hmm. So I do want to pull in a question from the audience real quick because it's about something, Joe, that you said earlier. They wanted a little clarification on what you meant by registering copyrights early to be eligible for statutory damages. What do you mean by that?
Sure. So the minute you get published, let me take a step back. There are certain things that you can do. It depends on what you want to do. So I'm just going to use traditional publishing. So if you're getting published by Big Five, indie, university press, they're going to register your copyright. And you're going to see in your contract that's usually within a 3-month window. So they want to do that in order, because the process time to get it registered takes time. It could take weeks, it could take months. So you want to register it as early as possible, just in case there is, potential copyright infringement. And the reason why you want to register it, like I said before, is that you're not eligible to file a lawsuit for copyright infringement, and you're not eligible for statutory damages. So to say what statutory damages are, they're particular damages under the Copyright Act. They can range from anywhere from $30,000 to $150,000 if your infringement is willful. So if you bring a copyright infringement lawsuit, and you can have a couple counts of copyright infringement, and that can get over that $75,000 threshold. Let's just say you're dealing with $100,000 for it. So you're able to get that. But if you don't register it, say your book publishes right now, September 1, 2021, but you don't register it until September 1, 2022, but the infringement happened 6 months ago, you're not under the Copyright Act. You're not going to be eligible for those damages. You still may get a certain amount, but you're not going to be eligible for those big tens of thousands, hundreds of thousands of dollars in damage. I don't know if that answers the question, but I know it's a long-winded answer, but everything in copyright law is complex, unfortunately.
So I want to talk a bit about what an agent's responsibility is with a writer. Jen, are all agents technically publishing, or do they have to have a knowledge of publishing law, or does every agency have their designated lawyer, or where do writers turn to if they need this sort of help? Does their agent serve as that person?
So I actually have a clause in my agency agreement where I make it very clear that if I sign someone on the agenting side, I am not their attorney. If somebody wants to hire me, a non-client wants to hire me for publishing consulting, that's definitely a discussion that we can have. But basically, literary agents don't need to have a legal background. They don't need to be attorneys. A lot of them happen to be attorneys. I can think of a handful that used to be corporate attorneys and then decided to make a change and go into agenting. So it is extremely helpful, I think, to have a legal background, but it's not a prerequisite for being an agent. I think more important is to have somebody that has the depth of knowledge in terms of publishing contracts, because they are very specific to publishing. And there are certain terms that, an average attorney, they wouldn't know what to do with just because they haven't come across it, like terms of art, how royalties work. So I always say to potential writers that if you're having an attorney vet your publishing contract, make sure it's actually an attorney that has practiced publishing law and specializes in publishing law. But yeah, agents, we wear a lot of different hats. And one of the hats that we do wear is making sure that our authors are protected as much as possible. When I write nonfiction proposals, I always, of course, it's an unspoken rule that it's confidential and not for distribution outside the publishing house. Joe, do you have anything to add?
Yeah, I actually, similarly, I have a provision in my agency contract that says I'm only going to be your agent. I cannot be your attorney here. And also for ethical reasons, because I have an agency and I'm a solo practitioner, I can't crisscross both businesses. So you don't have to have legal knowledge to be an agent. There are plenty who are incredibly successful. They know the market. They know what sells. And a publishing agreement, after a while, it tends to be sort of the same thing. Maybe there's some things that are different depending on current litigation, but generally speaking, it is similar. But at the same time, there are many times when I'm going over an agreement, and I think to myself, I wouldn't know what to do if I didn't have a law degree or know certain provisions even outside of publishing, or just even knowing what a severability clause in a publishing contract is, which is in literally every single contract that you'll come across. But just knowing those little things that that I just feel that's where the value comes in of having a legal background. And then not only that, to have the publishing contract knowledge, but also when you're looking at a project to see you may want to, think about changing the wording here or there for defamation purposes, for, you may be violating a right of privacy. So it's not just the publishing contracts, but it really helps having a publishing attorney because they know the industry and they may know things that someone who isn't an attorney knows about.
I find that fascinating because in my granted limited knowledge of publishing law, I had assumed that if you get an agent who's also an attorney, well, hey, you get two for the price of one. So it doesn't work that way.
Mm-hmm. Right. That's how I run it. Yeah. So I don't know if, I know like the bigger agencies, like like ICMs and Endeavor CAs, they have their own business affairs department. So they have their own attorneys, and I know agencies that have them as well. So they have someone in-house, but it gets more difficult for people who are smaller like myself, where, I've had to tell people I can't take you on because, I took you on as an attorney, so I can't take you on as an agent, or vice versa.
So Jen, if you have a client who you're repping as an agent who gets into some legal trouble, or they have something they need to do, what do you do? Do you just advise them who they could go to for help?
Yeah, so typically what I do is I kind of take a step back and look at the situation. I might give them some advice with the understanding that this is just my professional advice, not necessarily as an attorney. But yeah, if it involves litigation or there's any threat of litigation, I typically refer it out to another attorney that I trust. And we pretty much all know each other, I feel like, because publishing is a pretty small world and there's only a handful of attorneys that really practice publishing law. But yeah, I think it's really important to look at the big picture and really ask yourself if it's something worth pursuing, because litigation can be extremely costly, and oftentimes settlement is a better answer. So I do refer out if it's a situation that warrants that.
So I want to talk about the publishing contract because this is such a big topic. So I'm going to start with just a more general question of what considerations go into preparing a contract and what your role is in doing that. So Joe, let's start with you on this one.
Sure. So it all depends on the type of contract. So if it's from a publishing house, the agent doesn't prepare it. So the publishing house has their standard contract, and then you go in and you negotiate it. The opposite happens if I'm an agent and I send it out to my client. So I'll be preparing an agency contract. Excuse me. Same thing goes for other types of things like ghostwriting agreements, collaboration agreements. We'll prepare those as well. So, is there a specific one that you'd like me to talk about in terms of what goes into?
I guess just in terms of traditional publishing, when you're signing a book deal from a publisher, what goes into those kinds of contracts?
Sure. So I don't want to speak for any publisher, but I think, if I could put that hat on, what they're looking at is trying to get, as many rights as possible, to be honest with you. When you look at the contracts, they're very publisher friendly. I think they're going to try to see what they can get out of you for less money and royalties. And that's why you have the agents to say, well, no, what you have here isn't going to fly. They're going to try to look at they have an indemnification clause in there, and that usually is ironclad. That's actually one provision that is just usually non-negotiable. There may be some aspects of it that are, but generally speaking, most agents I would believe just don't have much success in that. Same thing for subrights. They're going to want world rights. That's usually the standard that I've seen. Depending on if it's a smaller publisher, they may say, hey, we don't have the reach to get to an international publisher. So they may say, oh, we'll just take North American rights or US rights. But generally speaking, the bigger publishers, they want as much as they can. And that's what you're going up against.
Jen, do you have anything to add to that? I have a follow-up to this as well, but I want to give you a chance if there's something else you want to say.
Thank you. I think Joe pretty much gave sort of the lay of the land. As an agent, we pretty much negotiate the publishing contract with the publisher. And I always tell writers, I know sometimes it's a long time coming and you get super excited when you get that contract. And by the way, it takes time to get that contract from when you get a deal. Sometimes it can take months to even get the contract. So I just want people to understand the sort of timeline in traditional publishing is a little bit more prolonged. But basically, we're negotiators, we're problem solvers. That's what we do as agents. And, my boss has been in the business for 21 years now. So we have a lot of contracts in our database that we can reference. And I will say the extremely big agencies, they have clout, they have negotiation power. Sometimes they have a little bit more leverage because they have some superstar clients, for instance. So I do think that it's really important to make sure you align yourself with people that have been in the industry for a while. That's not to say younger agents shouldn't have a chance. I always tell writers, if you want someone really going to bat for you, be open to newer agents. They're really hungry. And they really want to work hard on behalf of their clients. So I'm kind of getting off on a tangent, but basically everything in the contract is negotiable, never accepted at face value. There are certain provisions, like Joe said, that are much harder to negotiate, like warranties and indemnification. Like 9 times out of 10, the publisher will say no to any change you want to make there. But in general, everything is negotiable.
So that was actually the exact words of my follow-up, which is how much is negotiable. But I did have a secondary question to that. And Jen, I'll start with you. When should a writer know when to say that's not good, that's not enough? Like at what point? Because like you said, most authors are very excited. They have a contract. Of course, they just want to sign it. But when do they step up and say this isn't enough? We have to do something about this.
Yeah, I mean, I think it varies for the individual, but in general, like I always ask for an escalator clause for my royalties. So, if a certain amount of quantities are sold, the writer should be incentivized to sell more copies, right? So they should also get more royalties as the quantity goes up. And I think I've only had a few situations where the publisher very few, outright refused an escalator clause. Another thing is there's often what's called a rights grab. So that's when the publisher tries to grab all the rights in the beginning and say, I want world rights, I want all languages. A lot of times, a writer doesn't know what to do. They're like, oh, they want everything? Like, do I give them everything? Do I hold back? And so, if you work with an agency that has a foreign rights agent, there's that conversation with that foreign rights agent. Does this book have potential to sell overseas? Yes or no? If it does, then a good agent will try to retain, let's say the book has potential to publish really well in France. They'll do a carve out for that territory and language. So I think it's really, really important to kind of check in with your gut too and your intuition. If something feels icky, definitely get someone who is seasoned and experienced to help you out.
Mm-hmm. Jody, anything to add to that?
Yeah, so I've done a lot recently on the law side, a lot of hybrid publishers, and it's totally different than traditional publishing in terms of their contracts, where, for those who aren't familiar, you basically pay a publisher to publish your book. And quite frankly, sometimes it's thousands upon thousands of dollars. And a lot of times, authors aren't going to be happy with it. And, there are just certain things that you want to make sure to negotiate for, to make sure you can even get a refund. Like what happens, if you're not happy with their services, things of that nature. But just going back to what Jen said, it really, and I agree, it depends on your book. I think what the strategy you want to utilize, or at least one of the strategies, is what works for you. Where do you want to sell your book? Of course, everyone's always going to say, I want it to be the most popular book, I want it to be a bestseller, et cetera, et cetera. But, that's not going to be every book. So, what's going to work for you? Are you okay with just selling in the US? Do you want your agent to have, to go, work with a foreign agent, a foreign rights agent? To publish it elsewhere? Are you okay with, non-escalation clauses like Jen was just saying, or is that something that you want? I think, what you should do is sort of look at your contract, and don't be afraid to state your own value, because they clearly want to publish you, unless it's, a vanity press, but they've been, so to even get to that point, you've had the editorial meeting, marketing, publicity, and sales, they're all on board and they want to publish this. So even though you may not have an agent from one of the big four agencies, that doesn't mean that you still can't look at the value of what you bring to the table. And don't be afraid to negotiate. That's it. It always, especially for the hybrid publishers that I just came across recently, the authors literally just wanted to sign it. I'm like, no, if you sign this, it's terrible. You're assigning your rights. It's like an 8-year contract. You're not gonna be able to get out of it for a long time. So don't be afraid to negotiate. They expect you to negotiate. And they know that you're going to come back and say, I need more money. I need more royalties. That people expect that. So don't be afraid to do that.
Yeah, I always advise writers, always ask for more money up front, because that's when you have negotiation power, because you could technically walk away, right? So I think it's really important to have an agent, for instance, represent your interests, because our job is to represent the writer's best interests. We only do well if our client does well. And we have a fiduciary duty as literary agents, so, ask for more money up front and also pay attention to the back end royalties. It's really, really important.
Mm-hmm. And that more or less answered my next follow-up, which was how much does a writer need to know about what's in the contract, and how much can they just trust their agent to do the right thing? So Jen, do you want to address that a little bit more?
Yeah. Typically, I actually show my red line to my clients. I actually tell them exactly what I'm changing, and I want to make sure they're on board with it before I send it back to the contracts department. And I do get a lot of questions from them because, typically an author would be like, this is the first contract and I don't understand this term. Can you explain it to me? So I think our job as agents is really to break down the contract in plain language, like what exactly a certain provision means. So it's really important for me, at least, to keep in communication with my clients and be transparent about the process, because I feel like so much of publishing happens behind closed doors. So I try to lift the curtain a little bit and show them how the sausage is made, so to speak. But basically, yeah, I think it's really important that writers also educate themselves as much as possible. So good on everyone that showed up today. Nice job. Learn about publishing law, learn about copyright. It doesn't hurt to learn as much as possible.
Do you have anything to add to that?
Yeah. So I sort of do the same thing. I call my clients. I will literally go through every single provision and say, here's in plain English, here's what they're talking about here. That's my goal as an agent and an attorney. My goal is to have you know more about publishing than when, before you contacted me. And then, sorry, what was the second part of the question? I had something in mind, but I forget what I was going to say.
I think it was how much a writer needs to know and how much they can just trust their agent to.
Yes.
Yeah.
So yeah, I think look at your agent. Are they communicating with you? Are they just signing the agreement? Obviously that would be a huge red flag. But are they answering your questions? Are they going to bat for you? And I think, and you'll know that you'll know because they're going to come back to you and say, hey, we have this offer. I'm going to negotiate it this way and that way. And then, the other thing I wanted to say was, in terms of, understanding copyright law. So there are a lot of different resources. You go on copyright.gov, they have circulars. They're like numbered into I think the thousands. I don't quote me on that. I don't remember, but it'll literally be about, here's one on grant of rights. Here's one on work for hires, et cetera, et cetera. So it breaks it down into very plain English for a lot of people. So that's just one free resource that you can utilize.
Mm-hmm. So I want to get into some audience questions because we have a lot of really good questions coming in and some big questions. So I want to make sure we save time for those. So first off, I want to ask both of you about how you got into publishing law. This is the complex question. So I'm going to ask a couple questions at once, but if you need a refresher, just let me know. So how did you get into publishing law? Are you also writers? Would you recommend that lawyers who are writers pursue publishing law? And is it more competitive than other forms of entertainment law? So pick and choose there. If you want to refresh how much questions were in there, let me know. But Joe, let's start with you on this one.
Sure. So I have a pretty circuitous route to getting into publishing law. So I actually wanted to be an editor out of college and grad school, like every other English major. I actually met my wife at the NYU Summer Publishing Institute. I always like to joke that I felt like I was on The Bachelor, where I walked in. I didn't know how skewed the industry was in terms of males and females. I was like one of 7 guys, and I was like, oh my gosh! And we ended up, dating, and we're married. We have a son. I feel like I gave her the rose. That's what I always like to joke about. But during that course, I saw 2 panels, one on agents and one on lawyers, and I never thought to even to do that. And I thought, that seems like what I want to do. I like that I would get to go to bat for for authors. I'd have some editorial work to do, so to sort of use my creative side. So it seemed like it was utilizing a lot of different things that I was interested in. So I ended up going to law school. I had all my internships at publishing houses, except for my first one, which I just cold called, and I'm still amazed that I got it for William Morris at that time. So they just and it ended up being the publishing attorney that just so happened to be like, oh, this is fantastic. So it confirmed that I wanted to do it. And then I ended up interning at Rodeo, Columbia University Press, Hachette. The thing with publishing law, to get into the other part of the question of how competitive it is, I feel like that there are a lot of law firms that used to do it, and there aren't as many now. Even like the bigger ones, it's not something that a lot of firms focus on. So that could technically make it a little bit more competitive because there just aren't the numbers aren't there. So I actually ended up working at Sony Music after law school. So I did something totally different. Which was a blast. I absolutely loved it. But I knew I still wanted to do publishing. I did a little stint in financial services, and I just knew doing IP law, but knew that really wasn't for me. And then what had happened is people started contacting me through my wife's network, through my network, knowing that I did publishing. That I practiced publishing law, or at least was interested in it at that time. And then one thing led to another, and I made a go for it, and here I am, a couple years later, my own practice and my own agency.
Mm-hmm. So, Jen, if you want to go into your journey and the competitiveness of the industry, and then I want to get back to one of the other questions there as well.
Sure. I'll try to give the abridged version because my path to publishing literally looked like this. I went to college as an art major. I studied art, actually, and my drawing professor gave me a C+. So I was like, see ya, I'm out of here. Became an English major. I was lucky enough to take some classes with the general counsels at WashU at the time. And that's when I was first exposed to copyright law and intellectual property. And I got really into it. We had to do a hypothetical case on fair use, and I just loved it so much. And I've always been a writer, actually, more on the newspaper side. I was managing editor of our paper. At one point, they're like, do you want to be editor in chief? And I was like, I don't know. But I basically decided to go to law school. I mean, it was honestly on a whim. And I always tell people, like, if you're going to go into 6 figures of debt, really make sure that this is what you want to do. Even to get into law school, it's very, very competitive. I mean, I went to a pretty great law school. It's not Harvard, but I think something like 2,000 people applied for, at the time, 2,000 people applied for a class of less than 300. So it is really competitive to even get your foot in the door. And then after that, you have to take the bar exam, and not everyone passes the bar exam on their first try. So that's another hurdle. So I think there's a lot of steps that you need to go through to become a publishing attorney. So it is very competitive to sort of get your foot in the door. I was lucky enough that after law school, a couple of years after, I ended up being of counsel for the New Press, which is a not-for-profit publisher. And at the same time, that's when I started talking to agents. I actually didn't know that this was a career path. I never read the acknowledgement section of any book. I'm like, oh, that's like the Oscar speech for the authors. No one cares. But that's where they thank their agents. And I was lucky enough to get in touch with an alumni from my law school who had started his own agency. So I was literally doing 2 internships at the same time to get my foot into publishing. But yeah, basically publishing law became something that I ended up doing because people knew I had a legal background. They asked me for help. So that's how I came into it.
And then real quick, Joe, are you a writer as well?
Yeah. So I dabble with, fiction, nonfiction writing, various articles and blogs. So I think that also helps in terms of if you're looking for an agent, if there's someone who at least actively tries to write, whether it's, a short story or whatever it may be, they'll at least have the creative juices flowing where you can run things back and forth, where it's not just segmented, that they're just here to, send your work to editors. And I just think that they'll get a better feel of what your work is about. I think that's just an added bonus to have, and I imagine I would bet 99% of agents have at least either written something or have attempted to.
All right. So next question, this is another 3-part question. I'm going to do one part at a time. So Joe, we'll start with you again. Is it plausible to be in negotiations with several publishing houses at once?
It all depends. You can be. So it's if you have an auction, I guess that's when it would happen. But technically speaking, at least from the situations I've been in, when it's gotten to the contract stage, generally speaking, it's sort of like an implicit rule that you're going to go with that publisher. But it doesn't mean that if something doesn't come along that you can say, hey, I'm going to be in. So what usually happens is that if an offer comes in, it's really before negotiations. And Jen, correct me if I'm wrong here, but that's been my experience, where publisher A offers you something, and then you go out to all the other publishers and say, we have an offer, and then they come back, and then that could potentially be an auction. That's where you negotiate with multiple publishers. But if you're already at that stage, I found that it's very rare where someone somehow comes in and says, I'll give you a better offer. I'm sure it's happened, but in my experience, that hasn't been the case.
Jen, anything to add to that before I move on to the second question?
Yeah, no, I think Joe pretty much covered it, but typically, the best case scenario is you get multiple offers from multiple publishers. And at that time, that's when you decide whether or not you're going to hold an auction, and negotiate the deal memo and the deal points then.
Like I just had an auction. So yeah. Yeah.
The second part to this question, Jen, we'll start with you on this one. Could you touch on defamation laws with nonfiction books?
Yeah, so defamation is an area of law that is pretty complicated, but basically it protects anyone from being written about in a false manner, and it has to be injurious to the person's reputation. So there has to be real harm, and there's different standards for private versus public figures. So for public figures, you actually have to prove actual malice. It's a little bit higher standard. So yeah, it's really, really important for nonfiction, especially if you're writing memoir, to make sure somebody who understands defamation law sort of vets your manuscript, or at least the problematic parts of your manuscript. I always tell people, like, if it's true, then don't worry about it. Truth is a defense, and of course, the writers are just like, well, I said really horrible things about this person. Are they going to come after me? Like, is it true? So, there's some wiggle room there. What is truth, right? I mean, we get into all these like sort of philosophical debates, but basically it's what you can prove in a courtroom, right? So it's definitely something to think about. And I think Joe has done a lot of defamation review for his manuscripts as well. And my list is actually primarily nonfiction, so I do run into that issue a lot. And even if you're just like quoting somebody else's work, you need permission. So I think it's really, really important to understand sort of the contours of it all.
And Joe, do you have anything to add to that?
Sure. Yeah. So like Jen said, I've done several of them, and you look at, defamation. If you're doing a pre-publication review, you look to see if they're violating copyright law, sometimes even trademark law, believe it or not. It's rare, but First Amendment law as well in terms of defamation. So yeah, defamation it's false statement of fact, and you want to make sure that like Jen had said, if it's true, it's okay. That's generally the defense. But even to say it's my opinion, that's the one thing that you have to look out for, because if you say just using my name, Joe's an alcoholic compared to I think Joe is an alcoholic, that could be just as defamatory. So there's nuance to it. So, and the fact that it's state-based too, it's not federally based, just like copyright law. So every state has its own version of this. So you would have to see if, what state would apply, whether it be the state that you're in, whether it be the state that the publisher is in, depending on, where your book is published. But generally speaking, you're looking for that. And then the thing that's also related to what Chen had said is that the right of privacy. So that's a little different, where even if you say something that isn't defamatory, you could still get sued for right of privacy. An example being, you said something that affects someone's livelihood. You said a fact that was not supposed to become public, was supposed to be left private, for example. That really gets into, it's sort of like fact finding when it gets into court. So those are just two examples. So I always say that just because something isn't defamatory, you're not technically off the hook yet. And then you also have to look at right of publicity. I just had to do this as well, where I had a client who wanted to write a novel, and the main characters were celebrities. So, well, there's all these different right of publicity laws that you're going to have to, you're going to be entangled with. So that's the thing that you have to think about as well. So I know it's a lot. There's so many things that, are sort of intertwined, but that's publishing law for you. It's all the laws that are creative in nature. That's what you're going to be wrestling with.
There are so many good questions coming in here in the Q&A, so I'm trying to get to as many of them as we can. Sure. Let's say, so there's another one that's kind of a two-part that two people have asked this question. So, Jen, we'll start with you on this one. How does a publishing attorney make money, and what are your costs for negotiation help with publishers?
So it depends on the attorney and their experience. Both Joe and I typically charge in the range of $300 an hour, so it's not cheap. But we're also fairly efficient. We try to get the things done fairly quickly. So it can be hourly. Some attorneys are open to doing flat fees depending on the project. So Joe and I are actually in the process of forming a law firm. So hopefully that'll be launching next month. But basically, I think you can pretty much find a publishing attorney to represent you on these issues within your budget. Again, it's not cheap, but I think it's a worthwhile investment.
Do you have anything to add to that?
Yeah. So I would just in terms of, just to give people a general sense of like what attorneys charge and what's cheap versus expensive. So like for Jen and I, like a 300, even though that may seem like a lot, it really isn't. Like compared to like a big law firm where you're having thousands of attorneys, they may charge $1,000 an hour, $1,500 an hour, depending on who you're talking to. So and depending on where you are, if you're in the bigger cities, like New York, San Francisco. So yeah, I think for like, it's such a niche position, because I think a lot of people, and this goes back to what you're saying, the earlier question, I think a lot of attorneys either want to go into music, like I did initially after law school, or movies. There are more positions out there. It pays more. So I just think if you're going to be an entertainment attorney, you're more likely going to be in that sphere. And then, with publishing, it's a little different. But at the same time, the way technology is going, the way the digital world is going now, it's all becoming intertwined. Like I'm sure Jen has got questions like this, but working on authors having to go on TikTok and social media, and there are social media laws that you have to look into. So it's like it's all becoming interrelated. And then what you have to look out for if your author wants to go on YouTube. So even if you are just a publishing attorney, yes, you're going to know about books and that sphere of things, but it's all coming together where you really have to know a lot about the digital world to really best represent your client, at least in my opinion.
Mm-hmm. So next question, and Joe, I think actually one of your recent newsletters addressed this, but I'm going to ask you first on this.
Oh, sure.
What can a person do if they're in a contract and they want to get out of it?
Sure. So there are a few different things that you can do. So it all depends. First thing you want to do is look at the grant of rights. Make sure you didn't assign anything to the publisher. If you granted the rights, fantastic, you still own it. If you didn't, that's going to be a problem. Then you want to look at, and Jen, feel free to add once I'm done. The out of print clause. The out of print clause sometimes will have thresholds where if you're not selling a certain amount of copies or a certain amount of money per, a certain amount of accounting periods. So for example, $100 or 500 copies in 2 accounting periods, which would basically be a year, then it'll go out of print. You also want to look at the term of the agreement. Sometimes the term will literally be for the life of the copyright, which is your life plus 70 years. But a lot of times, even though it seems like you're like, oh my gosh, how am I ever going to get my contracts? A lot of times the contract will have a term, and it'll say this contract is valid for 3 years or 5 years or 7 years. And just see if there's sleeping on, the other thing you want to look at is see if they're sleeping on their rights. You can, instead of just getting out of the contract, maybe there's a certain right that you want. You could see if you could, revert that. And then the other thing I always tell clients is outside of terminating the agreement, because once you do that, it's basically severed the relationship with the publisher. Make sure you want to do this, and what are you going to do if you want to go to another publisher? Make sure you know what you want to do with it. So there are certain concerns that you want to look at, and for instance, the other one would be if your book isn't getting marketed or publicized enough. Well, maybe it's not that you want to get out of the contract, you're just mad that they're not marketing in a certain way. So talk to your publicist, talk to the publicist or publicity department. So there are certain things that you can look into outside of that may still keep the relationship going if you are happy with that.
Jen, do you have anything to add to that?
Yeah, I mean, I always tell clients and other people that I work with in publishing that, sometimes you are unhappy, but that's not a reason necessarily under the contract to be able to terminate. And it's very lopsided. I mean, there's an imbalance in terms of negotiation power, and typically the publisher has more power in that sense. But like Joe said, there's different ways you can carve out exceptions. You can try to get a rights reversion for those rights that they're not exploiting or marketing. So there's different ways to do it. And I definitely think that's a good time to sort of loop in a publishing attorney to help you with it.
And then we have a clarifying question for Jen. Why would an agent negotiate to retain rights for a specific region, such as France? What is retaining rights about?
Yeah, so in the foreign space, and I'm not a foreign rights agent, we have a dedicated foreign rights agent at our agency that sells abroad. But basically, if she feels in her professional judgment that the book has foreign potential, it's almost always better for the author to retain those rights, meaning keep those rights, because then she can sell to all those different territories for more money than you would have gotten through the publisher. So a lot of times there's this sort of tug of war between the foreign rights agent, the agency, and the publishing company, because 9 times out of 10, the publishing company will say, we have our own foreign rights department and we can also sell this. But keep in mind, when they're doing that, it's a subsidiary right. It's not an initial print right. So you only get a percentage of that. Whereas if you have a foreign rights agent negotiate, oftentimes the terms are better. So it really depends. I mean, I think it's the type of situation where, not everything travels, and our foreign rights agents really blunt. Like she'll say, this is too American, or I don't see this selling abroad because of X, Y, Z. So it's important to have somebody that sort of understands the lay of the land in the international market too.
Joe, do you have anything to add to that? Yeah, so I actually have a specific situation. So I have it's the unofficial Disney Parks cookbook. It ended up being Wall Street Journal and USA Today bestseller. So she's a debut author. So at the negotiation table, it was either world rights or they're going to back out of it. So at that instance, you're like, well, okay, we want and it's a big 5. It all depends on the leverage that they have versus what you have. And this goes back to what Jen was saying. If you're at a bigger agency, they may have more leverage at that point. So at that instance, we've had a few of those books. They're getting translated, I believe, into Italian, Spanish, and I forget the other one, but that's just an instance of the publisher doing that. And there would be better terms if the foreign rights agent would look at it. So I guess for your book, you want to determine does my agent know enough people in certain territories to negotiate this? What do I want out of this book? Do I just it's because I've had books where it's literally just too, like Jen said, it's too American. Like, just not going to publish anywhere else. So I tell them hey, we can try for work, but I don't think it's going to be as successful. So sometimes you just have to tell your clients you just have to be blunt with them. But everything is fact. I hate saying that because it's it depends. It's like the classic lawyer answer, but it really does. It depends on your book and what you want out of it, and what your agent can, or attorney for that matter. If he knows people in the industry, or he or she knows people in the industry, what they can do.
So I'm going to do a 2-part question here. Joe, we'll start with you. Who or how do you get permission to use song lyrics, quoting other people's work in your work? And then also if you could touch on the use of brand names in fiction, if you're allowed to do that.
Yeah, sure. So the song lyrics and the text. So generally speaking, the publisher should have a form that you could use. So I'll just go back and here's how you get the permission. So song lyrics, and I say this just because I used to work at Sony Music. Music publishers are very, very litigious. For one example, there was a video of a baby dancing to a song by Prince. It ended up going to federal court, and I believe through the 2nd Circuit or the 9th Circuit. But you would think, my baby's dancing to Prince. Who cares? But they have things, and I'm sure people have come across it, where they have takedown notices. So on YouTube, stop playing my music, even if you're not the one playing it, maybe it's somewhere in the background. So I say that as a caveat. I just say that they're incredibly litigious. So how you get the permission from Songwriting, you go to the music publisher, and they'll want to know how you're using the song, how you're using the lyrics, how many lyrics you're using, what's your print number, how many languages is it going to be in, how many formats, ebook, audio, hardcover, paperback, et cetera, et cetera. So the more you answer yes to all of those, the more your fee is going to go up. And it also depends on the lyrics that you're using. If it's the Beatles or Bob Dylan, I can imagine they have a very, very hefty fee. So for that, I say to authors, just just make up your lyrics. Then there's also fair use, where you could, all depends. If you're writing a novel, if you're just setting a scene, then it's likely not going to work. But if you're analyzing your lyrics, if you're writing a book about, say, Bob Dylan, and his lyrics and what they mean to Americana, you're going to be analyzing, so it may fall under fair use. So text text is it's different, but it's similar. It's different in that you're not going to a music publisher; you're going to have to go to the copyright owner. I guess for songwriters, the music publisher is the copyright owner. I don't want to misstate that. So you're going to have to go to the copyright owner, but it's usually a contract rather than for song lyrics. You're like writing an email or a letter. But for text, it's a contract that you're going to go to. And then what was the last part of the question? Oh, brand names, right?
Yes.
So, but brand names, it's very interesting. So that goes more into trademark law, with trademark infringement, trademark tarnishment. So for the bigger brands, you want to make sure not to say that, like, your main character was killed by eating a hamburger at Burger King. Anything that's defective, that's dangerous, that can potentially be trade libel in a sense. So you want to be careful of that. But can you use brand names? The answer is yes. Can you say your character wears Nike sneakers? Of course you can. You just want to make sure that you're not saying anything that could be associated, that it speaks badly of the company. That's really what they're out for. They want to make sure that nothing is out there that people think, oh, wait a minute, if this person, if I do X, Y, or Z, they're going to think my product is dangerous or defective. And the example that's actually outside of publishing, I haven't seen the show, but the crock pot in This Is Us, I guess it burned down the house, and there's a whole discussion about that as to whether you can do that, and how is that legal, blah blah blah. So that's just another example, more visual example, I guess.
Dan, do you have anything to add to that?
No, I think Joe pretty much covered it, but anytime you're quoting somebody else's work, like the best practice is always to get permission, whether it's a lyric, whether it's a poem. And it doesn't matter how little you take. Sometimes they have an argument under fair use, it's de minimis. And we don't have time to get into the fair use defense, but basically always ask for permission. I mean, if you were the writer and you were being quoted, wouldn't you want somebody to ask you as well? So I think that's the best practice.
So next question, a couple people have asked this actually, and it circles back into the defamation discussion that we had. Can you write about a person and not use their name, just their actions in nonfiction? Where is the line there? So Jen, let's start with you on this.
Yeah, I mean, that's definitely one way to sort of protect yourself. Another way is to make like a composite characters. That's another way you could protect yourself. But if it's clear from the actions, like if it's clear who that person is, it's identifiable, then not having the person's name attached to it might not actually afford you enough protection. So it really, like Joe says, it depends. It's on a case-by-case basis. But I always advise people, think about composite characters. Sometimes that can work.
Joe, do you have anything to add to that?
Oh yeah, Jen basically, covered it. You just want to make sure that somebody reads and say, that's me, because that's when, you may be in trouble. So you just want to do whatever you can with changing the names, changing the characteristics, changing behaviors, et cetera, et cetera. So that's definitely one way you can do it.
So let's get one more question in here. Joe, I'll start with you. Do you recommend that new authors hire a publishing attorney to review their agent contract? And then a follow-up is would you rather use an in-house attorney or hire somebody yourself? What would you recommend there?
Sure. So I would recommend, I always tell my prospective clients, please hire an attorney. And this is actually what goes back to what Jen was saying, but hire somebody who's a publishing attorney rather than, someone who's a personal injury attorney. So yes, I would definitely hire that. And what works for Jen and I, and the fact that we're attorneys and agents, is that we know what the agents are going to want in their agreements. So not to, have a personal plug for both of us, but yeah, that would be one advantage to having us represent you. So yes, I would definitely have somebody take a look at it, because it all depends on what's in the agreement. They may, like for me, for my contracts, I just include that book that you're working on. Some agents will be like, I'm your agent until the end of the world. So it all depends on what you want. And how much you trust this agent. And sometimes relationships break down. It's just, it happens. So that's why I would definitely make sure to have somebody take a look at it. And plus the publishing attorney will know the customs of the industry. If someone's charging like 40% as an agent, that's not right. And there are other ethics perspectives as well from the agenting community that that person have to know about. Anyway, it's an exaggerated example, but I hope that answers the question.
Definitely. Yeah. Jen, do you have anything to add to that?
Basically, I agree with everything that Joe said. I mean, you want to make sure when you get into a relationship with an agent, it is a long-term relationship. At our agency, we sign an author for their career, so it encompasses anything that they would write in book form. But always understand that you have the power to terminate the relationship as well, and really pay attention to those termination provisions because they can be somewhat strict. You might not be able to walk away with your subsidiary rights after the project has sold, for instance, because the publisher retained those rights. So it's definitely important to negotiate the contract while you still have negotiation power, and that's before you sign the agency agreement.
Mm-hmm. So very last thing is somebody asked what your agency will be called or how people can find you. So Jen, let's start with you. How can people find you and what will the agency be called?
If you're interested in querying me as an agent, I just reopened the queries. You can just go through my query manager link, which is in my Twitter bio. If you're interested in contacting either one of us for legal services, I'll give my email to Josh, and he can pass it on to whoever wants it. But basically, Joe and I are in the process of forming our law firm, probably sometime this fall. And the name of our firm, very, very exciting, is Perry, Chen, Tran, PC, because we just couldn't come up with another name. And typically lawyers like to use their last name. So I thought we thought it was the simplest solution. But just don't hesitate to get in touch if you have any questions at all.
Mm-hmm. So real quick before you go, Joe, I just want to tell all of our listeners, we're going to include links to this in the show notes. So and any of these links that you two want to send me, please do. And Joe, go ahead with how people can find you.
Oh, sure. So if you want to query me as an agent, you can go to my website, perryliterary.com. And I have a little, contact us sheet that you can fill out. You can also email me, jperry@perryliterary.com. And I know you'll send these links out. And for my law firm right now, before we merge, you can go to josephperrylaw.com, and then my email is jperry@josephperrylaw.com.
Awesome. So Jen, Joe, thank you both so much. This was such a fascinating discussion. There are so many questions we didn't get to. So to anybody who didn't get their question answered, I'm going to include all the links to the resources. Hopefully you can find your answers. Jen, Joe, thank you very much for being here today.
Thank you so much for having us. It was a pleasure.
Yes, thanks so much. It was a blast.
Absolutely. So to our listeners, we'll be back next week, same time, same place. We're talking to Ken Liu about his journey. So until then, we'll see you all next time.